Okay, welcome to our webinar covering the basics of the Data Practices Act. Thank you for joining us. The Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions and provide legislative assistance. The PowerPoint is posted on our website where you registered, and you should be able to click the link on this page to get to our website. We also record our webinars, so if you miss part of today's discussion or want to go back and watch it again or find one of our prior series, they are posted on the Data Practices Office YouTube page. You can find more information at the URL listed on this slide, and and we'll have another slide later with more information on accessing those resources after the webinar. Today's webinar is focusing on the Data Practices Act and walking through the basics of the law. We'll cover the public policy behind the law, important data practices officials, handling data requests, and more. We'll then wrap up with a Q&A session at the end of the webinar. So please feel free to send in your questions as you think of them using the Q&A panel on your screen. To get to the Q&A panel, you'll select Q&A at the top of your screen. If you don't see the Q&A option, you may need to click the More button, which is the 3 dots. From there, you can open the Q&A. You can start sending in questions now, or you can wait until the end of the presentation. One note about the Q&A here, though, you do have the option of submitting questions anonymously. And so if you choose to do that, just know that we might not be able to follow up with you afterwards if we don't get to your question. And so you may just have to reach out to us once again and ask that same question. Lastly, there is a raise hand function available here in Teams. We aren't using that today, so we won't be taking people off mute in order to ask questions. So if you have any questions, do please put that in the Q&A on your screen. All right, let's hop right in. Let's start with looking at the public policy aims of the Data Practices Act. Specifically, the law is attempting to balance 3 goals, which are often competing. First is the public's right to access data about the government so the public can understand what the government is up to. In other words, it's a freedom of information law. Second, the law contemplates the privacy of individuals from whom the government has collected data. After all, the government maintains a lot of data about people, which can often be sensitive. So the Data Practices Act is also a privacy law. Finally, the law attempts to balance the government's ability to efficiently carry out its functions while also being responsive to data access and privacy concerns. The Data Practices Act is unique when compared to other states' laws when it comes to balancing these policy goals. Other states often have separate laws addressing freedom of information versus privacy, and ours is the only one that combines them into a single law. Now let's turn to the Data Practices Act itself, which is contained in Minnesota Statutes Chapter 13. At a very high level, the law starts with the presumption that government data are public. It classifies different types of data as not public, and the state legislature makes these decisions about classifying data by amending the law. The Data Practices Act provides rights to members of the public and data subjects to access government data, and it requires data on individuals to be accurate, complete, current, and secure. Additionally, Minnesota Rules Chapter 1205 provide further clarification and guidance about the requirements of the Data Practices Act. The rules apply to data on individuals, but they are a helpful resource for entities managing data practices considerations. I also think it's helpful to clarify who the Data Practices Act does and does not apply to. Specifically, the Data Practices Act applies to all statewide agencies, statewide systems, and political subdivisions, such as counties, cities, and school districts as examples. However, the Data Practices Act does not apply to the legislative branch or to the judicial branch. Rather, both the legislature and the courts have their own set of rules for how members of the public can obtain information from them. Additionally, the Data Practices Act does not apply to townships that are outside the 7-county metro area. Townships within the metro area are subject to the law only if they are exercising powers under Chapter 368 of Minnesota statutes. All township boards are still subject to the requirements of the open meeting law, though. A term that I'll keep using throughout this webinar is government data. So let's just take a minute to define what that means. Government data is defined as all data collected, created, received, maintained, or disseminated by any government entity, regardless of its physical form, storage media, or conditions of use. In other words, government data are the various types of information government entities create or receive on a daily basis. And they can be in a variety of different formats, from paper documents to videos to emails to files on external hard drives. The key point to remember is that the information needs to be documented in a tangible format in order to be government data. Conversations or mental impressions are not data, which has been litigated. I also want to highlight just a couple other laws that do have an impact on entities' data practices that everyone should be familiar with. First is the Official Records Act, which requires government entities to preserve all records necessary to have a full and accurate knowledge of their activities. In other words, this law requires government entities to create records that document their official work. Second is the Records Management Statute, which requires entities to create record retention schedules documenting the retention time of their various official records. These schedules are approved by a records disposition panel, and official records can be destroyed only in accordance with that retention schedule. Just to add a little more context, this is essentially the life cycle of government data. Basically, the Official Records Act focuses on the creation and maintenance of government data. Once that happens, the Data Practices Act governs how an entity administers those data as it relates to data access, classification, and data security. Finally, the Records Management Statute establishes how long an entity must maintain specific official records and when the entity can destroy those records. I recognize it might be challenging to draw a distinction between government data and official records, but here is a graphic that might help. Essentially, all official records are government data, but not all government data are official records. Rather, only a subset of data that a government entity designates as documenting its official functions are official records that are subject to record retention requirements. If government data are not designated as official records, then those data are merely transitory in nature and can be destroyed when they are no longer needed. Meanwhile, official records must be kept until the retention period expires. Digging a bit deeper, the Data Practices Act does not create requirements for how a government entity must maintain data. So there's no specific format or system an entity must use to organize its data. However, the Data Practices Act requires that data be maintained in a way that is easily accessible for convenient use. In other words, government entities must have some type of organizational system in place to ensure they can easily access data when needed. There are many different ways that government entities can organize and maintain their data so long as they understand where those data are and can access them for work-related purposes and to respond to data requests. A government entity telling a data requester, "We don't know whether those data exist," probably isn't appropriate and would suggest an entity is not maintaining data in a way that is easily accessible for convenient use. The Data Practices Act identifies two different types of data: data on individuals and data not on individuals. Data on individuals includes any government data where a living human being is identifiable as the subject of those data. Examples of data on individuals include an employee's telephone number, the name and address of an adult arrestee, and an Athlete of the Week photograph. All these examples are connected to a specific identifiable individual. Meanwhile, data not on individuals are all other government data that are not about a specific person. Examples of data not on individuals include the makes and models of fleet vehicles, names of companies that are preferred vendors, or a list of government websites. Additionally, the Data Practices Act classifies all government data into one of three categories of access. First are public data, which are available to anyone for any reason. As I mentioned earlier, the Data Practices Act starts with the presumption that data are public. But the legislature does classify certain data as not public, and you can find most of those classifications within the Data Practices Act. So the first restrictive classifications are private data on individuals or non-public data not on individuals. These types of data are available only to the subject of the data, employees within an entity whose work assignment requires access, other entities as authorized by law, and those who the data subject authorizes to access the data via informed consent. The most restrictive classifications are confidential data on individuals and protected non-public data not on individuals. These data are available only to employees within a government entity whose work assignment requires access, and other entities specifically authorized by law. Notably, data subjects cannot access confidential or protected non-public data about themselves. Ultimately, a lot of data practices work comes down to determining whether requested data are classified under the Data Practices Act. Well, let's briefly turn to the various staff at an entity who have data practices responsibilities. First is the responsible authority, who the Data Practices Act identifies as the person responsible for overseeing all data practices obligations within a government entity. We'll talk about who those folks may be on the next slide. Next is the Data Practices Compliance Official, who is designated by the responsible authority as the point person to address any questions, concerns, or any other data practices issues that are happening at the entity. The Data Practices Act does allow the responsible authority to also serve as the DPCO. The responsible authority may also appoint data practices designees, who are individuals throughout an entity authorized to receive data requests and are responsible for overseeing requirements related to maintaining data. Finally, I just note that every employee within a government entity has some data practices duties, whether it is compiling data that are responsive to a data request, making sure they are organizing data efficiently, or securing not public data. Okay, let's turn back to who a responsible authority might be at an entity. In many situations, the responsible authority is designated by law, and Section 13.02, Subdivision 6, and Minnesota Rule 1205.0200 describe who that person is. At state agencies, the commissioner or other official appointed by law is the RA. The elected constitutional officers are the RAs for their respective offices, and the chief executive officer or other official appointed by a governing body is the RA for smaller agencies and boards. At the county level, each elected official is the RA for their respective office, and there does need to be an employee appointed as RA for all data outside the elected officials' offices. Additionally, the County Social Services Director and County Veteran Services Officers are the RAs for their county agencies. At cities, the RA is the individual appointed by the City Council, but until then, it's the City Clerk. At school districts, it is the person appointed by the school board, but until then, it is the superintendent. Let's turn to one of the biggest aspects of the Data Practices Act, data requests. Both members of the public and data subjects have a right to request access to data, whether it is to inspect data or obtain copies of data. There's no specific processes for how individuals must submit a request, but Section 13.03 does indicate that entities must establish procedures to ensure they receive and comply with data requests in an appropriate and prompt manner. Practically speaking, we suggest that government entities establish procedures requiring requesters to submit data requests in writing. This helps ensure you have a record of the request and can track it easily. We've also seen some entities move to using data request portals, which are permissible under the Data Practices Act. That said, we strongly encourage government entities to still honor written requests submitted directly to the responsible authority or to data practices designees due to the language of Section 13.03, Subdivision 3. Additionally, some entities establish a dedicated email address where data requests can be sent. However, you'll want to make sure several employees have access to the email inbox so that data requests are not being missed if someone happens to be out of the office. One quick note on disability accommodations here. Both federal and state law require government entities to provide reasonable accommodations upon request, and the requirements also apply to data request processes. Our office is not the expert on these laws, but we can say that government entities should have procedures in place for a member of the public to make requests for accommodations to the data access processes if necessary. If entity staff are unsure of who to contact about accommodation requests, the person who handles accommodations for an entity's employees would be a good place to start. And as we talked about with the last slide, these obligations still must be met by entities who utilize online portals for data requests. Again, our office doesn't decide what may or may not be reasonable accommodations, and we encourage data practices staff to work with their colleagues who handle ADA considerations within an entity. So, what does an entity do when receiving a data request? It depends on the type of request. If the entity receives a data request from a member of the public for public data, then the first thing to do is figure out what data are being requested. If it's not clear, then the entity should clarify with the requester. Next, the entity needs to respond to the requester, and there are three acceptable responses. First, the entity can inform the requester that no data exists if it does not maintain the requested data. Second, if responsive public data do exist, then the entity should compile those data and provide the requester with access to the data. Third, if the data exist but are classified as not public, then the entity needs to inform the requester the data are not accessible and cite a specific statutory section, temporary classification, or federal law that allows it to withhold access to the data. Additionally, entities are obligated to provide clarification and explain the meaning of certain data, such as providing definitions of technical terminology, explaining abbreviations, or describing any coding schemes. The process is similar when an entity responds to data requests from a data subject, but there are some additional considerations. Again, entities should follow up with the data requester if anything about the request isn't clear. Next, the entity needs to search for data and respond in one of three ways. If data do not exist, the entity must inform the requester of that fact. If the data exists about the requester, then the entity should provide access to those data. Of course, the entity must verify the requester's ID before disclosing any private data. Section 13.04 also states that once a data subject is provided with access to data about themselves, the entity is not typically required to provide access to those same data for another 6 months. If data are classified as confidential about the data subject, private data on someone else, or otherwise not public, then the entity must inform the requester that the data are not accessible and cite the applicable statutory section. And again, the entity must explain any technical terminology, abbreviations, acronyms, etc. when asked. One issue DPO has been seeing more often is whether entities must respond to large or time-consuming requests. The short answer is yes, because there is no overly burdensome exception in the law that allows an entity to outright deny a data request. So, some practical suggestions for how to process requests may be to contact the requester to clarify the scope of the request to see whether there are specific timeframes, combinations of keywords, or specific topics that could be considered in order to hone that request. Entities may also want to give the requester information about the amount of data that are responsive to the request and how that might result in longer response times. Sometimes requesters aren't aware of how much data they've requested, and this conversation can help hone the request. Another strategy an entity can consider might be asking whether certain requested data should be prioritized or over others, which can help direct the entity's work. Lastly, entities may want to consider providing data on a rolling basis as the data are compiled, which may spread out the work over time and give requesters an opportunity to narrow a request once they have a better sense of the data. There are a couple of things that entities are not obligated to do in relation to data requests. First, a government entity is not required to create data in order to fulfill a data request. If an entity does not maintain the data, then there are no data to provide to the requester, which is an appropriate response. Additionally, an entity is not generally obligated to change the format of data, such as scanning paper copies into an electronic format upon request. Additionally, entities are not obligated to answer questions such as why were these data collected or when will these policies be changed? Rather, entities are obligated to respond to requests for data. That said, the Data Practices Act does not stop entities from answering questions for customer service purposes. Also, the data practices compliance official is obligated to respond to questions about data practices issues that requesters raise. The deadline for entities to respond to requests depends on who is making the request. When the requester is a member of the public, the entity must respond in an appropriate and prompt manner and within a reasonable time. These terms are not defined, and the amount of time in which an entity must respond to the request depends on the request itself, such as the amount of responsive data, the complexity of the request, and time needed to redact any not public data. To be clear, an entity cannot put off responding to requests indefinitely. Rather, there's no firm deadline that I can offer for when an entity must respond to a request for public data from members of the public. When the requester is the data subject, then an entity must provide access to data immediately if possible. Otherwise, the deadline to provide access is 10 business days, which is a hard deadline. And to be clear, simply acknowledging the request is not sufficient to meet that 10 business day deadline. Rather, entities must provide the requester with access to data within that deadline. Additionally, what entities can charge when responding to data requests depends on the type of request. If the request is to inspect data, which means the requester will go to the entity's offices to view the requested data, then an entity cannot assess any fees related to that inspection. The Data Practices Act is very clear that inspection is always free, regardless of who has requested the data or the amount of responsive data that exists. When a requester asks for copies, then an entity may charge specific costs and additional considerations come into play. If the requester is a member of the public, then an entity may charge 25 cents per page for 100 or fewer pages of black and white paper copies. However, if there are more than 100 pages or the data are in an electronic format, such as a PDF, then the entity may charge actual costs. These costs may include time to search for and retrieve the data, time to make and transmit copies, and costs of other materials to provide the copies, such as the cost of a flash drive. One note here, search and retrieval costs must be calculated according to the lowest paid employee at the entity who can complete the work of gathering those data. If the requester is a data subject, then an entity may charge only the actual costs to make and transmit the copies, as well as costs related to materials to provide the copies. Entities cannot charge data subjects for the time to search for and retrieve data. Also, I do want to call out that the Data Practices Act makes clear that an entity cannot charge for the time spent redacting any not public data. So, any actual costs that an entity assesses when providing copies of data to a requester cannot include those costs related to reviewing data to determine whether it should be redacted or for the redaction process itself. One final note here. The Data Practices Act does not require an entity to charge copy costs, and it is up to each entity whether it will charge such costs. Additionally, these costs are the ceiling of what entities may charge, and an entity can always choose to charge less in copy costs if it wants to. Okay, we're heading into the final slides, and I'll highlight some other important aspects of the Data Practices Act. First are Tennyson warnings. These notices are required when a government entity collects private or confidential data directly from an individual. A Tennyson warning must include a statement of the purpose and intended use of the collected data, whether the individual can refuse to provide the data or is legally obligated to do so. Explain any consequences that may result from providing or refusing to provide the data, and identify other individuals or entities who may have statutory authority to access the data. Importantly, there's no one-size-fits-all model Tennyson warning that my office provides because the warning does need to be tailored to the specific data collection process. So, entities should work with their legal counsels to make sure they are drafting and providing Tennyson warnings that meet the requirements of the law. Remember, government entities may share private data with others only when a specific state or federal law permits sharing. And entities may only use private data for the reasons specifically identified in the Tennyson warning. However, other situations might come up, such as data subject asks an entity to share private data with a third party. An entity wants to share data with a third party but doesn't have statutory authority, or an entity wants to use private data in a way that's different from what was explained in the Tennyson warning. In these situations, an entity must obtain informed consent from the data subject before disclosing the data or using it in a different way. Informed consent must be in writing, meaning that a verbal yes does not work. Also, the consent cannot be coerced, and the data subject must voluntarily agree to data being shared or used without any fear of penalty. Lastly, entities also must explain why the new use or sharing is necessary and any known consequences for consenting to that sharing. There are a few other requirements I do want to call out. First, all government entities are required to have a data access policy for members of the public as well as data subjects. Additionally, entities must prepare a data inventory of all private or confidential data on individuals that they maintain. And just a note on this slide, those links should be live. And so if you're at a computer, you can certainly click on those links and they should come down, bring you to our website. And so you can find our model data access policies and our inventories on the website there. So moving on, the Data Practices Act also has requirements related to data breaches, which are situations when someone accesses private or confidential data without authorization and intends to use the data for non-government purposes. When a breach occurs, entities are obligated to provide notice to affected individuals, as well as investigate the breach and document findings in a report. Additionally, the Data Practices Act gives data subjects the right to challenge data about themselves that they believe are inaccurate or incomplete. An entity must respond to these challenges within 30 days by either correcting the data or informing the data subject that the data are accurate as is. A data subject may appeal an entity's determination to the Commissioner of Administration, who then has authority to make a decision about the accuracy and completeness of data. Again, you can find more information about all these requirements on the Data Practices Office website. Lastly, the Data Practices Act does have different remedies and penalties when an entity fails to comply with the law. Specifically, individuals may file an action in district court or at the Court of Administrative Hearings if they believe an entity has violated the law. And those processes contain specific remedies such as damages, costs, and attorney fees. Courts may also issue orders to compel an entity to comply with the law. Additionally, individuals can face criminal charges if they willfully violate the Data Practices Act, and we do occasionally see these types of criminal prosecutions. Public employees can also face suspension or dismissal if they willfully violate the law. Lastly, the Commissioner of Administration does have authority to issue non-binding opinions that offer guidance on the law. These opinions are truly advisory in nature, and an entity is not obligated to follow the Commissioner's guidance. However, entities that do follow the guidance may not be liable for compensatory damages or attorney fees if a court addresses the issues later. On a final note, the Data Practices Office does not have authority to enforce the requirements of the Data Practices Act, which means we don't accept any type of formal complaints alleging violations of the law. However, if someone has questions about what the law requires, we're always happy to provide any informal guidance and technical assistance that we can. So that is the Data Practices Act in a large nutshell, and we'll turn to the questions that you have. Please submit your questions in the Q&A panel. To get to the Q&A panel, you'll select Q&A at the top of your screen. Again, if you don't see a Q&A option, you may need to click the More button, which are those three dots. From there, you can open the Q&A. Again, you can submit questions anonymously. However, if we don't get to your question and you would like us to follow up with you, we will need you to reach out via phone or email because we can't see who asked the anonymous questions. Just a couple of other reminders on this slide that the slide deck is available on our website, and you can access the recording on our YouTube page in the next day or two. I'll also be putting an evaluation link in the Q&A panel here shortly, something that you can click on and then go fill out the evaluation for us online. If you fill that out and let us know how we did and what other topics you'd like to see in the future, we really would appreciate it. And from here, I'll stop talking and get to the Q&A. And if you hear a little bit of silence, that just means that we're reviewing the questions. Your computer or your device is still probably working. We're just working our way through the questions to make sure that we are finding the ones to answer. So I'll pause there and turn it over to everybody else.
Thanks, Casey. Just a housekeeping note here, and I'm publishing a question about the slides. If the links aren't working for you in the slide deck here, I am about to post in the Q&A link to our website where the slides are located. I'll pin it at the top as well. And from there, you can just scroll down to the bottom of the page and under Other Data Practices Webinars. If you expand that, you will be able to see a place to download the slides for today. So hopefully that will assist. Thanks.
All right, we have a question here that says, if an official record has been kept past the retention period and a data request was made for it, must it still be produced? I'm guessing yes, but wanted to check. You are correct, yes. If you're still maintaining the data and the data are responsive to the data request and classified as public or in a way that that person has access to that data, then yes, you do still need to produce that data for that data request. After you respond to that data request, since the retention period's up, you can destroy that record, do your destruction report, and then you will not have to produce it for future data requests.
Okay, we had a question. Sorry, Taya. We had a question asking if we can describe tangible format more, and this is getting to the definition of government data. You know, what data do these obligations, do these requirements, do these classifications apply to? And Casey talked about the definition of government data and how it has to be captured in a tangible format. What that's really getting at is that if a requester is coming to you and they're asking for data that don't exist, that aren't, you know, documented in some way, shape, or form. Maybe they want your opinion on something and you don't have a report on it, or you don't have correspondence about that. You know, your thoughts and opinions, if they're not captured, written down, recorded, that sort of thing, would not be considered government data. And so the obligations of the Data Practices Act would not apply to that. So you can think about like a phone conversation. If the phone conversation conversation isn't recorded, it's not captured in a tangible format, you can't share a copy of it, right? So that would not be considered government data, and the obligations of the law would not apply to it. Hope that helps.
Okay, we have a question about personnel data that says, in an employee's personnel file, should an employee be able to review their benefits enrollment and medical certifications that have been submitted as part of FMLA leaves? We currently include these documents in the employee's confidential personnel file. So the answer is yes. Those data are still going to be private personnel data, and private means that the person that it's about can get access. I think that confidential personnel file is more of an HR term and not a data practices term. It just means those files are kind of segregated from other types of personnel data that an entity might create or maintain as part of administering someone's employment. So it's not confidential in the sense of Chapter 13 in the Data Practices Act. Those data should still be available for the employee to review.
Okay, we have a question here. Just to confirm, you can charge to compile data to share, but cannot charge to redact any private data. So this depends on whether it's a request from a member of the public for public data, or if it's a request from a data subject. So if it's a member of the public asking for public data, you can charge employee time for search and retrieval, as long as the data are not being provided in paper copies. If there's paper copies, then the Data Practices Act says that the charge is 25 cents per page for paper copies of 100 or fewer pages. If it's more than 100 pages, or if it's other types of data like electronic data, that's when you charge actual cost. And so actual cost is the cost for an employee to search for and retrieve the data and to make and transmit the copies, but you cannot charge to redact. Now, if the request is coming from a data subject, so I'm asking for data about me, now you can't charge for search and retrieval. You can only charge for the time to make and transmit the copies and the cost of materials. You cannot charge for redaction, and you cannot charge for search and retrieval if it's a data subject request.
Thanks, Grace. Okay, I can hop to the next question. So this question asks, for subject requests, do we have 10 days from when we received the request? I'm the only one in my agency that takes care of data requests. So if I'm gone for several days, do those days count against my 10 days? So just to go back again, if you have a data request from a data subject and they're asking for data about themselves, you have 10 days to provide that data to fill the request. And yes, 10 days where you're out of the office, for example, would count. It's from the date that the request is sent. So if you are the only person doing filling data requests at your entity, I know a lot of smaller entities, maybe it's up to a person, I would definitely visit your procedures and make sure that you have backup so that your entity is seeing these requests from data subjects come in, even if you're out on the office, or say you have to go on leave for an extended period of time, because those 10 days will continue to count as you're out of the office. So it's important that you have procedures in place to ensure that you are filling those requests within the required time frame. Hope that helps.
Okay, we have a question about creating data. Please explain what is considered creating data. My agency receives many requests for data that may exist but is not available in an existing report. The law was written based on old paper records, not data stored in huge software systems that may have no built-in report functionality. So there's a little more to this question, but that's the general idea. And your obligation for government entities is to provide access to data in the way that you maintain it. And it's absolutely true that this was written in a paper for a paper world with a few adjustments for how we do business now. So if you have a large database, you still have to have some way to provide access to sort of the raw data within that database. There is a requirement to have data easily accessible for convenient use, as mentioned, which means that whatever we're using and creating to do our work as government, we have to be able to provide access to it. That doesn't mean that you have to create a research report doesn't mean that you have to compile something that doesn't exist within your entity already. The exception to that, of course, is summary data, which is a different obligation. But in general, you need to provide access to the data as you have it. How that happens, of course, will depend on how you maintain it. So certainly, again, whether it's in a database, whether it's in a paper file, whether it's a map, how you provide access can be determined by how you're maintaining it. But there is an obligation to provide access to the data, but again, not necessarily research an issue and create a report for someone on that topic.
I do want to just hop in here quick and let folks know that I have posted the evaluation link in the Q&A panel. It should be pinned there at the top. And so when you have a moment, please click on that and fill out the evaluation and let us know how we're doing. But yes, I think it looks like Grace is ready to answer another question, so I'll turn it back over to her.
Thanks, Casey. Yeah, so this question asks, for the amount of time to respond to a data request, what is a common reasonable amount of time to get back to the public? So there's not going to be a one-size-fits-all reasonable amount of time here. The Commissioner of Administration has explained that what is a reasonable amount of time is going to depend on the nature or complexity of the data request and the amount of responsive data. So how much data you are providing to the data requester. So what's a reasonable amount of time is really going to depend on what data is requested. So if somebody's asking for a single report, a reasonable amount of time is going to be a lot shorter than if someone's asking for all emails from the data practices office for the last 5 years. I don't know, something like that, where it's a very large request over a long period of time and you're searching for certain terms. That's obviously going to take more time than pulling a single report. So it really does depend on the data that's requested. If it is a very large data request where it might take months to compile the responsive data, that's when we encourage entities to engage with data requesters in providing rolling production. So start producing data as you have it available in batches. That's sort of a customer service aspect, but it can help in the relationship with that data requester and show that you are still working on that data request.
Okay, we had a question about retention. So is there a webinar available for retention, specifically how kept, destruction practices, etc.? So questions about records retention. You know, our office can provide guidance on the Data Practices Act, which doesn't really address sort of record keeping practices. There are some exceptions there for specific types of data, but generally speaking, you know, we would refer to the Minnesota State Archives they can provide some useful information on records retention. And having said that, we did partner with the state archives a while back now to provide a webinar on records retention and their work with records. So I am going to drop a link to that in the Q&A just so you have that for reference, and you can always find that, of course, on our YouTube page later on. But I would take a look at that, see if that helps you sort of understand some of your records keeping obligations. And if you have further questions about records management, you can always reach out to the folks at State Archives and they can assist as well.
Okay, we have a question and I lost it, but it was a question about internal emails. And it's from someone who I know happens to work at a law enforcement agency, but it says if a member of the public requests internal communications, specifically emails between two staff members who are working on a specific case involving that data subject, would that be considered public or private? And of course, the answer to that question is it depends. It depends on what's happening in the case. Is it part of the case? Is there active investigative data, at which point it would be not public, confidential, protected, non-public? Is it a situation where their name is incidental to the email? They're not actually the subject of the email, even if their name appears there. So it depends on the context of the data. It's not the format itself as correspondence or emails, but rather what do the emails say? What do they reveal? and then we get to what the classification is. So it's going to depend. There isn't a hard and fast answer on that. It will depend on what the emails say and whether or not the person is the subject, and then access and classification will follow from there.
All right, and it depends answer is probably a great spot for us to land the plane, data practices plane today. And so again, if you have additional questions, feel free to reach out to us. We really appreciate you attending the webinar and sending in those questions. Again, you can reach out at our email address here on this slide or give us a call. We're happy to answer those questions. Also, if we didn't get to your question today, we will follow up with you. And again, if you submitted it anonymously, please follow up with us and then we can answer that question too. Just a couple of other things here quick. If you're not signed up for our email list already, I encourage you to do so. You can do that on our website. You'll receive information on new webinars and workshops as they are scheduled. And we also send out a newsletter every other month about data practices and open meeting law issues. So again, thank you for joining us and have a great day.